We'll be covering the topic of consignments, an option worth considering. And we have John Eberhardt from Nikon, and we have Joe Coleman, founding partner from KRC&L, attorneys at law. So we appreciate your participation, gentlemen, and thanks everyone for joining. I just wanted, before we get started, I wanted to just mention a couple of things. If you have questions, we'd like you to ask them. Everyone's muted, but we do have a chat function with GoToMeeting, so you can click on chat, ask a question. I'll do my best to we'll do our best to get those questions answered throughout the presentation. We will be sending the slides as well as the answers to these questions out to you following the meeting. It usually takes we do our best to get it out next day, but worst case, probably get it out Monday. And with that, I think we'll go ahead and get started. You could go ahead and advance the slide. Thank you. So I want to just cover briefly the agenda. I know John and Joe will be getting into it a bit more. Starting off with just a brief intro on credit to be for those of you that aren't familiar. They're going to cover really go into consignments, why to consider consignments. Consignments as defined by Article 9 of the UCC, protecting your consignments, comparisons between consignments and PMSIs, benefits of using consignments for the consignors as well as the consignees, and the risks to consider as a consignor and how to protect yourself, and then we'll have a summary. We'll have a couple of polling questions, so look out for those, and your participation is, of course, appreciated.
Joe Coleman joining.
Hey, Joe.
Hey, Joe.
Was I the only one cut off?
No, we were all cut off, Joe. To everyone who's here and can hear us, we're just going through some technical difficulties right now. We're trying to get Tim Faherty back in. For now, since we have Joe Coleman and John Eberhardt here, what we're going to do is we're going to go on to their portion of the presentation. We're going to fast forward through the credit to be slides, and we'll start with just a little our speakers. John Eberhardt is the General Manager of Credit for Nikon. As you can see, they have a lot of information here that you can look at when we give you the slides when the presentation is complete. We also have Joe Coleman here, who is the Director and Attorney at Law at KRC&L. So right now what we're going to do is we're going to put up one of our polling questions. The first question that we have is, how knowledgeable are you on the topic of consignment? So if you guys could just take a minute and fill that question out, that would be great. And we'll just keep the poll open for a few more seconds.
Justin, can you hear me now?
Yep, you're in, Tim.
So strange. I don't know. I apologize, folks. I don't know if that was just me that was having the issue.
No, we
thanks
all
for hanging in there.
Yeah.
Oh, it was.
Tim,
Okay.
Just so you know, we have the poll up now. I'm going to close the poll, and I'll share the results.
Okay, great.
So as you can see, we basically have a share of between limited and average knowledge of consignments. So John and Joe will take this into effect and tailor their presentation towards this. And with that, I'm going to hand it over to them to start the presentation.
Okay. Have we done the introductions then, I gather?
Yes.
Okay. Okay. Well, thanks, gentlemen. Sorry for the technical difficulty, and we appreciate your participation and look forward to the presentation today.
Well, terrific. Thank you, Tim. Thank you. This is John Eberhardt, and thank you all for hanging in there as we went through this audio transition. And hopefully, we're going to be able to spark this up a little bit for everybody. First off, the topic today is one that a lot of credit people have had the requests made over the course of their careers, whether or not to consider a consignment transaction. And many have shied away from it. And yet, this particular tool is still actively used, not only domestically, but internationally, and to quite creative means for so many companies today. Studies show that in the area of Fortune 5 companies, probably a third are continuing to utilize it. And even though, while perhaps narrowly used among their customer base, it often can be a defining tool in securing a relationship and growing a relationship with a customer. They're offering opportunities to build relationships, solid relationships between the customer and the seller. And the greatest piece about this is so many people continue to believe that they will not have the capability to retain the title when they are utilizing this tool. And what we hope to demonstrate throughout this presentation is that is in fact not the case, and that by utilizing this tool, you can not only increase sales for your organization, but increase your ability to mitigate risk. So with that, let's find out a little bit more about it.
Good afternoon, everyone. This is Joe Coleman. First of all, I'll accept full responsibility for technical difficulties because I just think I'm contagious. I'm always having problems with technical issues. Let me ask a question before we get started. John, as a supplier, when do you think it's beneficial to retain title?
Joe, I think it's always going to be beneficial to retain title if possible. The reality is the decision to use consignment or not to use consignment in many ways is going to be dictated by the question of either revenue recognition or risk mitigation. And as we'll get into more of the conversation, we're going to understand that that change is going to vary from transaction to transaction. But one of the most important aspects of this, in the area of consignment, retaining title is a powerful, powerful tool.
Okay, great. Let's talk a little bit about what a consignment is. And we've got a general description. It's when you, as the supplier, maybe the manufacturer, maybe a distributor, you send your goods to your customer, like always, but you retain title. And then your customer sells them to their customers in turn the ordinary course of business. So they're your goods, but you own them in your customer's possession. That's what we're talking about. Now, if we turn to the UCC, the Uniform Commercial Code, which is in every state, and as of the last 10 years, it's even in Louisiana, and that would be very good. The Uniform Commercial Code defines a consignment transaction as follows. A transaction, regardless of form, in which a person delivers goods to a merchant for the purposes of sale. I think that's pretty clear. We could probably just wrap up this presentation now. Now, I mean, the problem with, I personally think, in my experience, people underutilize consignments, both for gaining market share and with good customers and as a protective measure in distress situations, because there is a substantial amount of confusion about consignments. And the reason there's a substantial amount of confusion is the Uniform Commercial Code, even when it was amended in 2001, has just failed to make it clear. Our goal today is to make it clear. So the Uniform Commercial Code says a consignment transaction, regardless of form, which means form over substance, or substance over form, excuse me, in which you, as a supplier, deliver your goods to your customer so they can sell them. And it's goods to a merchant. What's a merchant? The UCC says you can't sell them to yourself, you can't be an auctioneer, and you can't sell it to someone who is known by everyone to already be selling consigned goods or goods of others. So 99.9% of your customers are merchants. Let's move on. The Uniform Commercial Code only applies to transactions over $1,000, a materiality element. Then the Uniform Commercial Code says, and the goods we're talking about are goods that are not consumer goods immediately before delivery, which raises the interesting legal question of what the hell does that mean? Well, what it means is essentially, if you're delivering your dining room table to Sally's Furniture Consignment, that's outside the Uniform Commercial Code because that's not really in the stream of commerce. That's something the UCC doesn't apply to. And then finally, the transaction does not create a security interest that secures an obligation. So, and we're going to come back to this very aspect subsequently in the presentation, but if you're selling goods and you have a debt and you take back a security interest, well, that would fall out of a consignment, because a consignment is when you're delivering your goods. You retain title. You can't both own your house and then get a security interest to yourself. So either you're selling the goods, letting your customer have title, you take back a debt, and in some cases take back a security interest, or alternatively, you deliver your goods and retain title. And that's what we're talking about, the latter. You deliver the goods, you retain title. So really the bottom line, what we're talking about here is You deliver goods to your customer, you retain title, the goods are worth more than $1,000, it's not a consignment store, and you're not taking back a security interest. Now you're doing a consignment transaction, which is not a security interest. You don't take back a security interest. So that's our definition.
Well, let's see. I'm going to launch launch a polling question here, which is to see if everyone got it. What is a consignment transaction? If you can go ahead and fill out, select one of those options, and then we'll get back to it. And we're getting the votes are coming in. We'll give it another few seconds.
I would just caution everyone: don't overlook the fourth one. I have two daughters. I have two daughters and many proms behind me, and I wish I could buy them on consignment.
I'd say ship them to me. I've got a daughter, but she likes to change her clothes about 20 times a day. So, but she has 4. Okay, so I'll go ahead and close the poll here. We've got a lot of participation. Thanks everyone for the votes, and let me share this, and we'll bring it up.
Okay, so I just want to address this very, very briefly. So a consignment is when you are delivering your goods, your company's goods, to your customer. You are not selling your goods to your customer. You are delivering them, and you own them. You own them. Your customer has physical possession of them. So they don't owe you any money. Your customer doesn't owe you simply for you delivering your goods that you own. They don't owe you any money until your customer, sells to their customer. Then it creates a debt that they owe you. So it wouldn't secure a debt. And the deferred sales of goods, that's kind of a trick question. I mean, that would be you sell your goods to your customer, but you agree as part of the credit terms, for example, that they don't have to pay you until after they sell you, until after they sell the goods. But in a deferred sale, you are selling your goods to your customer. You're not delivering and just giving them possession. Okay.
All right.
All right, Joe. So with that in mind, understanding that the goal here in a consignment is to retain title, how are you going to protect that?
Okay. First of all, it's all about notice. Secondly, I always like to know my enemies. Who is going to potentially cause me issues with my consignment? I got rid of my customer because I have a consignment agreement. I'm not worried about my customer. It's the bank who has a lien on the inventory. It's the landlord who has a state law statutory lien on all property. It's the bankruptcy trustee or the creditors committee. Those are the people. The way we protect ourselves is notice. Notice, notice, notice. If your lender's foreclosing their lien on the inventory, I want them to know I have consigned goods there. If bankruptcy's filed, I want everyone to know, everyone to have notice, I have consigned goods at the debtor. If the debtor's selling substantially all their assets, I want the buyer to know some of those goods are mine, I've retained title. Now there's different ways of satisfying this notice, as you see on slide 11. And I'll just go through this very quickly. 50, 60 years ago, if you did a consignment, the traditional way was to have a sign that says, Joe's Goods on consignment. Well, that's just never going to work. The sign's gone in a day. That's really not ever going to work. Number two, if everyone knows your customer generally sells consigned goods, then they should be on notice. But I've litigated this issue in the Zales bankruptcy. There's been other bankruptcies in the jewelry business I just had lunch with someone yesterday that owns some jewelry stores. They said, yeah, we sell, all my suppliers give me jewelry on quote-unquote memo, which is consignment. I said, do they ever file UCC-1s? No. And in a lot of these jewelry cases, the consignor, the one delivering the goods, retaining title, if they haven't given the notice by filing a UCC-1, then you lose your consignment interest. So you see the red sign, red X through sign. If you call your lawyer and say, now I want to do a consignment, and they say, well, just put a sign over your goods at your customer's warehouse, do not run from that lawyer. The way you want to give notice, and the most important thing in protecting your consignment interest, is file your UCC-1. File it before you deliver goods. Okay, let's continue. Now, Article 9 of the Uniform Commercial Code makes it easy for you to protect your consignment. Now, you may be making an effort to increase your sales department's market in a particular segment of your market. So you're thinking about helping out your customer by doing a consignment, or you're in a distress situation and you're trying to protect your goods, and so you're telling management, let's do a consignment. You're trying to be creative. You need to know, how do I protect myself? Management will want to know, how do I protect myself? The Uniform Commercial Code makes it easy. You file a UCC-1, put the world on notice. For example, you're entering the consignment agreement. Your consignment agreement will say, I have the right to file a UCC-1. The Uniform Commercial Code says you can sign the UCC-1 financing statement. Your customer doesn't have to. So it's very easy. Figure out where they're incorporated, sign your own UCC-1, file it to the Secretary of State for that state of incorporation, and you've done it. Now, we have a notification requirement, but as far as the UCC notice, that's it. Pretty easy. Tickle your calendar for about 4.5 years to make sure you file a continuation statement, but it's very easily done. Now, one of the biggest problems with consignment sales is, if you don't file a UCC-1 financing statement and send the necessary notification, then you lose. Then your goods in the customer's possession that you thought you retained title, you'll lose your consignment interest because you did not put everyone on notice. You have to put them on notice by filing your UCC-1, and in addition, and we'll go over this in a minute, but I want to make sure it's clear, you have to send a letter, a notification letter, to the existing secured parties, those who have already filed UCC-1s, and let them know you're putting consigned goods in this customer's warehouse. Again, if you don't file the UCC-1, you lose. Okay, so let's go through a little bit of the rationale as to why the Uniform Commercial Code gives you this right for consignment. First of all, I'll take it from the bank's perspective. And in my case, you got to know your enemy to beat your enemy. So the bank's thinking, I go out to a borrower, I do my underwriting for the loan, I look at the inventory, I evaluate it, and I figure I can lend 75, 80 cents on the dollar. I advance money based on the borrower's inventory. Let's say John Eberhard at Nikon puts in $500,000 of consigned goods. And John doesn't file the UCC-1 because he's really sick of lawyers going on and on and on about UCC-1s. He's a bit of a renegade, and he doesn't file his UCC-1. But Nikon has $500,000 of inventory in this warehouse, and the bank goes out and they're evaluating their collateral. They look at $500,000 of Nikon product. There's no UCCs, no notification, so they're lending against it. Well, that's not fair. if John later, after the fact, says, wait, that's my consigned goods, I got a consignment agreement, that's not fair to the bank. And I hate to even say those words, it's not fair to the bank, but it's not. They did their underwriting, they looked at the UCCs on file, and they lent accordingly. So if John had filed a UCC1 saying, I have a consignment interest, then the bank's on notice. When they do their underwriting, they can understand, oh, I can't lend against that because I've been notified there's a consignment. So we also have in section 9.320, the first bullet point, that says, you know, as far as competing interest to your consigned goods, buyers of your customer in the ordinary course of business have a higher priority to those goods than you as a consignor. So, and that just makes sense. If I sell to a retail outlet and they sell to someone on Saturday afternoon, that person who buys the goods, in the Nikon example, buys the camera, well, of course they should have prior right and superior ownership than you as consignor. So buyers in the ordinary course of business defeat your consignment interest. 9.324 is purchase money security interest, and we'll talk about that in a little bit. So again, this notice that I keep talking about is the key to prevent the bank from being duped or the landlord from being defrauded. We just want to put everybody on notice because that maximizes the amount of debt in the commercial transactions. I'll give you another example of notice. I have an oil and gas client here in Texas, and they're doing a significant amount of transporting oil and gas from trucks to rail cars they own, but they're using someone else's facility. I don't have a consignment interest. I don't have a security interest. I just have my client just has a lot of equipment, heavy, valuable equipment. And so I filed a UCC1 simply to say, hey, this equipment, described as follows, is owned by XYZ Corporation, not by the person who owns the facility. So if anyone tries to say they have a lien on it later, I don't have to worry about it. So the UCCs are all about notice, avoiding secret liens, etc. Okay.
So Joe, the next question I put to you is this. We've had a lot of discussion, and if you go back to the definition, it says that a consignment is a purchase money security interest. So what about this confusion? Can you explain this one to us?
So let's just all read this. We're all on slide 15. It says under 9.103D, protects the consignor security interest by providing, quote unquote, from your Uniform Commercial Code, the security interest of a consignor in goods that are the subject of the consignment is a purchase money security interest in inventory. Now wait a second. A consignment is a purchase money security interest in inventory. I'm sure I'm going to violate a webinar rule, but let's go back to slide 9 just real quickly. And on slide 9, I told you at item 4 that a consignment does not create a security interest. And now I'm telling you 9.102A20 on page 15, back to page 15. Hope I didn't get anybody dizzy. I'm saying a consignment, or the UCC is saying, is a purchase money security interest. So the UCC is talking on both sides of their mouth. It causes confusion, and I know for a fact that this confusion limits how many people use consignments. So the goal at this part of the presentation is let's get rid of the confusion. So I want you guys to have consignment in your arsenal of weapons when you're dealing with trouble situations or other customers where you're trying to sell more product. Okay. UCC says to protect the consignor's interest, the consignment is a purchase money security interest. What they're saying is you protect a consignment by a purchase money security interest. Not that a purchase money security interest is a consignment. A consignor retains ownership of the goods in the possession of their customer. A purchase money security interest holder sells the goods to their customer, does not retain title, but receives a lien back. Okay, let's go to the next slide. Okay, consignment. Sells goods on consignment, delivered goods owned by supplier. That's what we've been saying this whole presentation. Let's compare it to a PMSI. Sells goods subject to a PMSI, delivered goods owned by the customer. So our major difference here is on a consignment, the supplier owns, let's go back one. On a consignment, the supplier, you, the seller, owns the goods in possession of the customer. On a PMSI, you sell the goods to the customer. The customer owns the goods. You get a security interest back. Those are significant differences. In bankruptcy and foreclosure, in exercise your rights and remedies, in one, consignment, those are your goods. Those are your goods. You have title. On the other, you sell the goods, take back a purchase money security interest. Those are your customer's goods. The customer owns those goods. You just have a security interest to the extent the value of the goods delivered. So the major difference is ownership. Who owns the goods? Now I'm going to take a second here. So purchase money security interest, you sell the goods to your customer. Customer owns the goods. You just took back a lien. Just like you own your house, or just like a bank lets you buy the house. The bank doesn't own your house. The bank just has a lien. In a consignment, you own the goods. Okay. Now let's go to how do we protect our consignment interest from the bank, from the landlords, from the trustee, from the creditors committee. And if we go back one more, the way we protect the consignment interest is by jumping through the PMSI hoops. Number one, you file your UCC that we talked about. Number two, you send a notification letter to all the pre-existing secured parties who themselves have filed UCCs, probably the bank, probably the landlord. And you do this before you deliver the goods. So a consignment is very different than a purchase money security interest. It's just protected the same way. A consignment, you own the goods in possession of your customer. Purchase money security interest, you sell them to your customer, take back a security interest. Two different things. But you protect your consignment interest the same way. Thus the confusion. If we go back one slide, that's what 9103 is saying. Your consignment is protected by a purchase money security interest. Okay, let's go forward. Again, proper filing of a notice of a consignment under the PMSI rules perfects or protects the consignor's lien to creditors, buyers. That would be buyers of substantial assets, not buyers in the ordinary course of business. Both consignment and PMSI statements put the world on notice. It prevents anyone from being confused. Okay? Let's go to the next slide. And just, to understand the difference between a consignment and PMSI, it would help to look at what a PMSI, or purchase money security interest, is. And then we can contrast it. A purchase money security interest allows a supplier to sell, as opposed to deliver and retain ownership, customer. But they let you, the Uniform Commercial Code lets you take back a security interest. So you sell goods to your customer, and the customer has a lien with the bank. And a bank has lien on all the inventory. But a purchase money lets you take a lien over and above the bank on your goods alone. So it's a substantial benefit. You have a first priority properly perfected lien against that bank or against your collateral, your goods. The reason the UCC lets you do a purchase money security interest like this is because in that situation you wouldn't sell your customer unless you got purchase money back. But for the purchase money, you're not selling the goods. So you're not taking collateral away from the bank. The bank is even. Before and after your purchase money transaction, you have not changed the bank's collateral. You've enabled your customer to have more inventory by the purchase money. The difference is when you get your purchase money, your customer owns the goods. You have not retained title. John, personally, I'm sick of listening to myself, so I'm going to ask you a question. When would you suggest a sale on consignment as compared to a purchase money security interest?
Well, as we discussed a little bit earlier, and by now, hopefully, everyone has gotten the big takeaway, which is this is about retaining ownership versus just taking a secured interest. So with that in mind, the reasons you would consider one over the other are primarily going to be around the issues of either A, revenue recognition, or B, risk mitigation. And then it also depends in great deal with regard to the product you're selling and the objectives of the business that you represent. Let's give some examples. There's the case where you are looking to introduce new product into the market. As such, it's untested, unsure, and yet you're willing to take some leveled risk in order to see how it's going to do. Most importantly, to get it out in front of your customers. In a case like this, a consignment arrangement is a wonderful way to begin to test the market and not burden your customer with the working capital charge that it might incur. Conversely, if it is absolutely important due to whatever requirements that the company may have, that there is clear revenue recognition, the purchase money security interest is going to be the way to go, because with a PMSI, as Joe has already stated, you are in fact transferring title and a sale has now occurred. But in that particular case, you can become secured yourself. Does that help, Joe?
You bet. And John, specifically, the more distressed the situation is, are you more inclined to use a consignment or a PMSI?
It really depends. I think that there has been a belief among many that consignments really should not be utilized with distressed debtors. And I would argue that there are times it can very well be utilized in that case and provide you with more security than you might have with a PMSI. And we'll talk a little bit about that as we get into what happens in an actual default situation. I would also say to you that what you need to be careful of in making these decisions is in the art of the actual agreement between the two parties. There is a great deal embedded in the agreements themselves covering such things as insurance, stocking levels, whether or not the customer can put the product back to you and in what condition. These are all considerations that would have to go into that negotiation. Lastly, one of the biggest considerations, and Joe, you alluded to it early on in the presentation, is your customer's own financial situation vis-a-vis their lenders. Their lenders may have some preclusion relative to allowing additional security, and depending upon the lender, one option may be more palatable to them than the other.
Yeah, I'll tell you, John, in a stress situation, if you have a purchase money security interest, I have a security interest. In order for me to get my goods, I have to give proper notice, quote-unquote reasonably commercial notice. I have to take possession of the goods. I have to hold a UCC foreclosure sale, and that's got to be commercially reasonable. There are a variety of hoops to jump through. If I have a consignment, they're my goods. I'm going to take them back. Okay. Procedure. So just one more item to show the comparison of a purchase money and a consignment, because again, we know that they're very similar in how you protect and how you notify people. To obtain a purchase money security interest, you have a security agreement from your customer. You file a UCC in the state of incorporation. You conduct the UCC search, so you know pre-existing secured creditors. You send out a notification letter to existing secured creditors to say you're providing purchase money security interest financing, and you have to do that because you don't want the bank to lend on additional inventory that you have a first lien. You're jumping over the bank. I always suggest, and then you do all this, the UCC and the notification letter before you actually deliver the goods. Otherwise, again, you're confusing the other lien holders. And then I always recommend conduct a UCC search after you've done everything to make sure the UCC is exactly as you expect, you properly filed, and then tickle your calendar. So that's a purchase money. How would a consignment be different? Well, on slide 20, we see two changes to the procedure. You have a consignment agreement instead of a security agreement, and you provide notification of a consignment instead of a purchase money security interest. So go back to 19 quickly. And this is how we perfect a purchase money security interest. Go back to 20. This is how we perfect a consignment. It's basically the same. And that makes sense because we said while consignment and purchase money are different animals, one you retain title, one you just get a security interest, we also said that you do the notification perfection the same way. So the procedures to effect a perfection of consignment are very similar. John mentioned a consignment agreement, and I think it's important that you have all your deal points in the consignment agreement, where you're going to deliver. You have to state expressly, this is a consignment agreement. I'm retaining title. You have possession of my goods, but I have title as a supplier. You're going to want reporting, so they have to report when they sell your goods, because at that point you're invoicing them. You want inspection rights. You have price. You have warranty. You have an authorization in your consignment agreement that you can file a UCC1, and you can notify pre-existing UCC filers, the bank. You want to make sure your consignment agreement notifies your customer, hey, I'm going to be sending a notice to your landlord and your bank and some other secured creditors. The last thing you really want to do is send your notification letter out to your customer's bank and have your customer's bank go berserk, declare a default on your customer. No, we want to have this all on top of the table. No surprises. John, what about some consignor benefits?
Okay, so now let's talk a little bit about the commercial side of this for both the consignor and for the consignee. Oftentimes a request will come in, and generally the requests are coming in from the sales department. Can you as a credit manager recommend or consider a consignment arrangement? You absolutely can if you have a strong knowledge about your customer. And this is where the value add from the credit department begins to take place with regard to the marketing and sales initiatives of each of your companies. What you really want to understand is the nature of the product that's going to be sold, the desire from a marketing perspective, the risks entailed with the customer, and what is the longer-term goal. For example, is this a request with a customer who is a key account for you, whereby you're looking to ship product in, but you know that on your side of the equation, your company has supply chain disruption issues? This could become a tremendous competitive advantage for your company if, in fact, you can eliminate that risk for your customer and allowing your customer to carry a consistent and much-needed product from you, but not have to burden his balance sheet, or said more clearly, take on any debt more than he already has to. You may, as we mentioned earlier, be looking to introduce new products into the channel and are willing to take the risk of having that product in there and basically test the market. It gets it out in front of your customers more quickly than you might be able to if you're trying to develop a market in a traditional manner. If it's moving through, you can restock the product quickly, allowing for additional value for both you and your customer. It reduces the risk entailed with introducing new products into the marketplace because you can test the markets. Most importantly, it's going to allow you to nurture a better relationship with your customer. So if we're hitting you all over the head with one point, we want to make sure you remember, don't shy away from this. And in point of fact, under a consignment arrangement, you retain the title to the goods. You can recover the goods on a consignee's insolvency. This one is my favorite. You have a chance.
John, let me interrupt here for a second. Upon your consignee's insolvency, so if your customer, the consignee, files bankruptcy, you can still go repossess your goods without talking to the judge?
Oh, no, counselor. I had a lawyer tell me, oh, that was you, that the last thing you ever want to do is just to be showing up at your customer's location with a truck thinking you're going to load up your goods. No. The very first phone call you're going to make in a case like this is to contact your corporate legal department and or outside counsel to guide you through the process necessary to get court approval within which to go after these goods. But as Joe is going to point out to you, speed wins in that particular case. With regard to the consignment arrangement itself, we made mention of the fact this is where the art is. It can be relatively inexpensive and easy to implement, but you have to make sure that it works for both parties on both sides, and that will include covering such issues as who is going to be responsible for insuring the goods, who is going to be responsible for the taxes related to the goods, what are the terms and conditions about where the goods will be maintained, what are the costs associated with reporting on those goods, how is the reporting going to take place between the two parties, what is the interval, who's going to do it. You're also going to want to make sure that if you're going to consider this, that you're going to have access to do the auditing necessary so that you can, in fact, keep very clear records on the transactions and avoid risk of loss. Now, on the consignee side, it can be very powerful as well, particularly if you're in a mode whereby you are very much concerned with, for example, getting that product out as quickly as possible in front of customers. If you're a manufacturer, ensuring that you have no downtime within your facility relative to production. You want to eliminate the risks of any stock outs that might occur with a customer. You also want to make sure that you're not adding debt to your side of the equation. You want to lower your investment in working capital. And by the use of a consignment, as we've already stated, title has not transferred to you. Thus, it is not new debt, and it's not new debt as it relates to your lenders. Payment to the consignor only following sale. It's a great, great tool and lowers your risk. And if you've crafted your arrangement properly, your ability to return the goods and the conditions under which you can turn them can be a very, very powerful advantage.
Okay, very quickly. Yes?
Tell us about those risks.
Okay. First and foremost, I want to leave room for Q&A. So I'm going to say you have to perfect your consignment interest. consignment agreement, UCC1, notification letter, before you deliver the goods. Otherwise, the existing security interest holders will be unfairly misled. And if we go to the next slide, continuing the risk of consignor, I'll make a point by an example. Scenario, or client A has a consignment agreement, doesn't get around to doing the UCC1. Their customer sells a bunch of the consigned goods, so they owe the consignor a fair amount of money. They don't pay. Consignor, client A, sues them, has a big, beautiful jury trial, gets a great judgment, and then they file bankruptcy. That's client A. Client B does a consignment agreement, files a UCC1, and sends notification letters to the existing secured creditors, and again, doesn't get paid. And again, the customer files bankruptcy. So who's better off? The client A, who's has a consignment agreement, has a jury trial, had a glorious day at the jury trial, has a judgment, or the consignor client B, who simply entered a consignment agreement, sent the notification letters and the UCC1s. Upon that bankruptcy, client B is in much better shape. All the jury trial did was give you an indebtedness that's no longer disputed. But vis-a-vis third parties, the bank, the landlord, the creditors committee, the trustee with their strong-arm powers in bankruptcy, they bust your consignment because you didn't perfect it. So the moral of the story is file your UCC1 and send you notification letters. Another risk, monitor your customer. If they change their name or they have a significant transaction, you have 4 months to file amended UCC1s. You always want to be able to identify your consigned inventory or goods that you sell to your customer. I had one client put little stickers on everything because their goods were not distinguishable from some of their competitors' goods at their customer's warehouse. And so if you have to take back and repossess your goods, you want to be able to figure out what they are. Now, Nikon cameras, pretty clear, it says Nikon. But sometimes you have to either use serial numbers or put little stickers or try to figure out a way if they're not distinguishable. Moving to the next slide. One more really important point is, and we did mention, but I'll reemphasize it just briefly, have your consignment agreement and tell your customer, I mean, this is a sales transaction, we will be sending notification letters to your existing lien holders so they have notification of the consignment. Give them a heads up. We don't want to cause any problems. Now, the final point I want to make on this slide, the last bullet point, what do you have a consignment in and what do you not? You have a consignment interest in the goods that you deliver and give possession to your customer. When your customer sells, in the ordinary course of business, you lose your consignment or any interest to the sold goods. Well, what about when your customer sells on credit? Do you get a lien on that receivable? The answer is no. Your consignment interest is only in the actual goods. Now, the UCC says your consignment interest is in the goods and the identifiable cash proceeds. There's almost never identifiable cash proceeds, save except a bankruptcy judge's order requiring them to segregate. So be mindful, what you have protection in is the goods you've delivered, but once they're sold, you lose that protection. Okay, bankruptcy considerations. I'm having fun now. When a consignor or when the consignee files bankruptcy, your customer files bankruptcy on slide 26. when your customer files bankruptcy, you need to call your lawyer immediately, because every hour you're losing consigned goods, because that debtor in possession is still selling your consigned goods. And once the debtor sells them in the ordinary course of business, you lose the consigned interest. So you're losing the value of your consignment virtually every day, every hour. So call your lawyer. To add insult to injury, now you're losing your consigned value, consigned inventory, and you're paying by the hour. But your lawyer has to get into the bankruptcy court immediately and say, wait a second, they're selling goods they don't even own. These are my client's goods. And at that point, you file an emergency motion, and it's done, and courts are used to it. And either you'll get adequate protection of some kind, maybe they'll give you a lien on something else, maybe they'll segregate the cash proceeds, you get a lien on that. Maybe they'll let you take possession of the goods. But you don't want to sit on your hands. You have really good protection. There's even some case law questioning whether consigned goods are property of the estate. So you have good protection in a consignment, but you lose it if you sit on your hands. Just a couple other bankruptcy-related issues. Many of you are probably familiar, who have been through the bankruptcy wars, with 503b9 claims. And a 503b9 claim says if you deliver goods and the customer/debtor receives those, the goods that the customer receives within 20 days of bankruptcy, you get an administrative claim. Well, the question is, on consigned goods, when did the debtor receive the goods? When you delivered physical possession, or when they sold them, then you're ready to invoice. Well, the court said when the debtor receives physical possession for 503b9 purposes, and I don't know that I agree with that, but that's what the Circuit City Court held. Now, I'm sure many of you are great fans of preferential transfers, the biggest legal shakedown in the world. Well, what about new value, the exception or the defense to preferential transfers? If you extend credit subsequent to receiving a preferential transfer, that's a defense. You get a deduct to your preference called the new value defense. Well, when does a new value defense kick in? When you deliver goods that you retain an ownership interest in, or when they sell them? And in the Felt case, they said no new value until they're actually sold. You extended credit when your customers sold the goods to their customers, because that's when you invoice them. That's when they start to owe you money. So these two courts are pretty irreconcilable, looking at consignments in two different bankruptcy scenarios. So this will continue to change into, we'll have more litigation, and I think at some point they'll get it right. I think I've probably used my time.
But it was time well spent, Joe. And there's a couple of questions, and I know we're running a little bit over, so...
That's okay, John. John, I get paid by the hour. That's fine.
That's fine. Consistency.
There you go.
So, in summary, Joe has walked us through very clearly the definition of a consignment under Article 9. And the big takeaway at the end of all of this is there is a difference between taking a purchase money security interest and filing in the form of purchase money security interest. What you are getting with a consignment is that you are retaining title to the goods. Don't be afraid of consignment transactions. There are benefits for both the consignor and the consignee, but as in all things, it is not a set decision based upon certain parameters. You need to understand not only the strengths and weaknesses of your customer, the strengths and weaknesses of their reporting systems, which Joe just alluded to, and I know that that's one of the questions that came up from one of the attendees. This is absolutely critical, not only in how you craft your consignment agreement, but also how do you actually act on it. Putting something into a consignment agreement is one thing. Don't put it in there if both sides can't actually live up to it. But done correctly, you can drive productivity, efficiency, cash flow, and cost reductions for both parties. The key is in that negotiation. Don't shy away from it. An effective consignment program is going to require the things that we have driven home today. You're going to execute an agreement between both parties. You're going to correctly file that purchase money security interest. You're properly going to notify all creditors, and you're going to keep up to date on them. This is not something you can draft, file, and walk away from. Certainly anyone who's been involved with consignments know this. And you need to understand your rights in bankruptcy and insolvency cases. And as we said, in all of these situations, speed is most important when something like this occurs, and that's when you're on your line to your corporate legal department and or your outside counsel, most generally both. I want to thank all of you for your participation, and we did have some questions that I saw came up. Tim, what do you think on time?
So everybody is still on. Yeah, I think if we can go maybe quickly through these questions, if you can give a short answer, and what we'll do is we'll also ask Joe and John to contribute. Just if you guys can answer these questions, as a follow-up, we'll send it out as well. But let me just go ahead and start. Question number one: in a consignment, we have easily identified our goods that are delivered, then sold by our customer. In a PMSI, how would we identify specifically the goods that continue to be protected under PMSI when the selling to the customer on open terms? Did you get that?
Joe, you want me to read that back?
Yeah, why don't you?
Okay. In a consignment, we can easily identify our goods that are delivered, then sold by our customer in a PMSI. How would we identify specifically the goods that continue to be protected under the PMSI when the selling to the customer on open terms?
Okay, so you're selling on open terms, which I assume you're selling on credit, say 30 days, but it's a consignment agreement. So you deliver the goods, and you say, once my customer sells the goods in the ordinary course of business, I get paid for those goods on 30-day terms. And that's a very standard way a consignment works. And as long as you have your goods identified and you jump through the hoops, you get to take back your goods if they default in paying you. But if the question is, well, they've sold the goods in the ordinary course of business, so I can't go after the goods sold, but I've given them 30-day terms. How do I go get those goods back, or how do I get paid for those 30-day terms? And I think that's a very good question, because it highlights a negative, I guess, of consignment goods. Once those goods are sold, the horse has left the barn. You never get that back. You only get an interest, and you only get repossession rights in the goods they have in their possession at the time you declare a default. You may have a lien identifiable cash proceeds, but that's almost never going to work. So what you've really done, compare two scenarios. Scenario one is I sold the goods at open account. Scenario two is I sold the goods on a consignment. I sold the goods at open account. They didn't pay me. I've got a lawsuit for a debt, and I've got no rights or collateral or anything. Scenario two, I sold the goods on consignment. They didn't pay. I put them in default. You get to go pick up all the goods they have yet to sell. That's the difference.
Okay. Can a UCC1 be filed on existing consignment account accounts, I'm assuming, covering goods delivered after the date of the UCC1?
Yes.
Right.
And it could be messy if you have to go repossess. And the bank with a prior interest will have something to say about it. But your consignment, and it's a great question, and your consignment will be good for everything you deliver after the notification letters and the UCC's filed. So at some point in time, you've got goods that are both subject to the bank's lien first, those that you delivered or and sold before the consignment, and you've got goods that you delivered after the consignment was perfected. You win on the goods after the consignment was perfected. You lose on the goods before the consignment was perfected. And then you have the added complication of first in, first out, last in, first out, how your customer's selling. So I may want to address that in a consignment agreement. And but what you so you do have complication complexities in the short term. Those complication complexities are better than nothing, and in the long term, they will have blown through the pre-consignment inventory, and you're clean.
Okay. How do you? The next one's really on monitoring. How do you control or monitor what's actually consumed? Basically, so if you think there is an inventory that has not been consumed, only to find out that it actually has been, but just not reported.
Well, that's another great question. Just let me throw out a real-life example, John, then I'll turn it over to you. In a consignment transaction we did in a distressed environment, we have twice-a-month reporting on what's sold, but your customer, the soon-to-be or potential debtor, they're breaching every agreement they have in the house. And breaching the reporting in your consignment agreement, they're not going to think twice about it. So that's a very important concern. In every consignment agreement I do, I always allow for very short or no notice inspection rights. And if I'm in a distress situation, I've got my salesperson or my local agent or someone showing up periodically on 0 or limited notice to make sure they're doing right.
I have firm agreement with Joe. One of the biggest weaknesses in all contemplated consignment arrangements is you can have the most well-crafted and perhaps even well-meaning consignment agreement drafted, but if the mechanics of monitoring and reporting the inventories as used, as consumed, and thus purchased is not in place, tested in advance so that you know it actually can occur, then you're wide open for risk. Further, even if those monitoring tools have been tested, are in place, have been utilized for quite some time, a credit executive cannot take for granted that protection is always going to remain. It is when a debtor becomes in financial distress that a lot of the controls will break down, and also the kind of transfers that you are hoping to avoid will occur. Back to Joe's point, this is why you want very, very lenient terms vis-a-vis the consignor in your ability to go in, take physical inventories, audit their positions on a regular basis, and if you are concerned in the least about their financial condition, you start putting greater and greater attention on this particular area, and it may in fact cause you to reevaluate the exposure that you have with that debtor.
Of course, you're still better than just selling an open account.
Right.
Tim?
Well, gentlemen, hey, I wanted we've gone past our allotted time, but I know we had a little technical difficulty on the front end, which I appreciate everyone hanging in there. We will send the presentation out with answers to all the questions, and I want to thank John and Joe for your time today, and love the interaction. I thought it was great. Great questions from the audience, so I want to thank you as well, and we will look forward to seeing you again soon. John, actually, if you move to the next slide, we can put up Joe's contact information as well. So if anybody has any questions or wants to reach directly out to Joe, there's the info, and mine's at the bottom of the slide. We'll send it out to you, too, if you have any questions about Credit to Be. Thanks, gentlemen, very much, and have a great day.
Thank you.
Take care.
Appreciate
Bye.
it.
Thanks. Bye.